Two big trials in the fight for democracy set for this April, and big news in both of those cases this week. First, in the Dominion $1.6 billion defamation lawsuit against Fox in Delaware's Superior Court, most of Dominion's motion for summary judgment filed against Fox was unsealed, with text messages and emails from executives all the way to the top to Rupert Murdoch, and hosts of the most popular shows on Fox were released. And it shows a concerted, malicious effort to boost ratings at Fox by intentionally spreading election disinformation. We'll talk about Dominion's motion for summary judgment and the implications of these messages. Second, in the E. Jean Carroll federal civil lawsuit in the Southern District of New York against Donald Trump, set for trial in April for defamation and civil sexual assault, a motion filed by Trump lawyer Alina Haba, and interestingly, not Trump's other lawyers, including his new lawyer, Joe Tacopina. This motion seeks to exclude evidence of other women accusing Donald Trump of sexual assault and excluding evidence of Donald Trump's own statements and recordings where Trump brags about sexually assaulting women. We will discuss what we think Judge Lewis Kaplan will do with respect to that motion, and it's not good for Donald Trump or Alina Haba. A theme on today's Legal AF: how MAGA Republicans want to bury the truth and lie to you, because sunlight is the biggest disinfectant to fascism and MAGA propaganda. So, to that end, we must also talk about how former Vice President Mike Pence is seeking to avoid Jack Smith's subpoena to appear before the federal criminal grand jury in Washington, D.C., investigating 2020 election interference by Donald Trump, on the grounds, Pence alleges, of the speech and debate clause privilege in the United States Constitution. In essence, Pence is arguing that he should be treated as though he was a United States senator, not a vice president, and as though his observations about Trump's attempts to overthrow our democracy constitutes legitimate legislative work of a United States senator. If you are saying to yourself, what? That is the legal version of what we are going to be, or the non-legal version of what we are going to be explaining to you. Also, just such a cowardly person. Also, the terrorist group, the Proud Boys, they want to subpoena Donald Trump at their current seditious conspiracy trial taking place in federal court in Washington, D.C. I mean, heck, the leader of the Proud Boys, Enrique Tarrio, was hanging out with Trump at the White House on December 12th of 2020, just like partying there in the White House and probably doing much, much more. There's also a numerous litany of other connections between the Proud Boys and Trump and Trump's inner circle. So we're going to explain what we think about this subpoena and what will federal Judge Kelly do, who's presiding over that case. And finally, portions of the Fulton County Special Grand Jury report were released. The non-important section, the less important sections, basically the introduction, conclusion, and Section 8. And Section 8 said that witnesses who committed perjury should be indicted. Those were the sections that were released. The other portions of the report, which actually contain the names of the people who the special grand jury recommends be criminally indicted, those were not released by Judge Robert McBurney to protect the due process rights of those who the special grand jury recommends be indicted. So what do you expect the gaslighting fascist coward Donald Trump to do? Well, he claims, thank you very much, special grand jury, for exonerating me, when the exact opposite is true. Every single thing that disgusting individual does, that traitor does, is just a complete and absolute lie, and we will tear those lies to shreds here on Legal AF. That's what we do. Ben Meiselas, joined by Michael Popak, donning a new set of glasses today. Michael Popak, how are you?
Lie shredder, Michael Popak, Ben Meiselas. When we started this show, it was all about investigations, arrests, and process and procedure. And now it's all about prosecutions and trials, just where we want it to be.
And the efforts by fascists, the efforts by these MAGA Republicans to avoid testimony. How can they try to skirt out of it? How could they try to obstruct? How could they try to stop the process? Because they are terrified of the truth. They are terrified of our legal system, because when the truth comes out, you know, you see things that happen, like with this Dominion summary judgment that was filed, which, look, we knew that Fox was engaged in horrific conduct, right? That's not a massive breaking news alert. Fox is a propaganda network. But when you see how the fascist sausage is actually made, there was something about reading these messages, Popak, that viscerally made me want to puke. Because as you see, you know, and it was also because then you see occasionally the clips of these, you know, these Tuckers and these Hannitys and these Laura Ingrahams, and like, you know, that they are propagandists. But when you see also how shallow, how callous, how opportunistic that these individuals will destroy our great democracy for a few extra bucks, is something that is just so vile, so sickening. And I hope, frankly, that Dominion doesn't simply win. You know, I hope there is greater and broader action that is taken. And I hope that by highlighting what is actually taking place, a movement to shut these fascists down can take form. And people may be saying, oh, that's pie in the sky, nothing's going to happen. Stop with the defeatist attitudes, because here on Legal AF, here with the Midas Touch Network, we don't have defeatist attitudes, okay? We work for our democracy. I understand the pessimism, and there's a lot of reason to feel pessimistic when people want to bring you down. But we fight for freedom here on the Midas Touch Network. We fight for democracy, and we expose the truth. And so I'll just read to you some of these messages that were in this summary judgment motion. And then Popak, if you could break down also, like, just even what is a motion for summary judgment? Why is it rare that a summary judgment motion would be filed by a plaintiff in a case like this? Usually it would be brought only by a defendant in a defamation. So for a plaintiff to say it is undisputed that liability has been proven, let's go to damages, is rare. And then I also want to get your analysis, Popak, regarding what you think the judge is ultimately going to do with this summary judgment motion. Regardless, the case is set for trial before Delaware Superior Court judge in April. But here are just some of the messages.
Can I ask a question? Before you read off all of them, and they're great. You've called them the Fox.
I'm not going to go that many of them, because
I want you to put them. But let me frame it. The reason why these are important, and not just sort of interesting, to find out how the on-air personalities, or what Rupert Murdoch calls the big three, Tucker, Hannity, Ingraham, internally, why this is important in a defamation case is because in order for the plaintiff Dominion voting systems to win here, or Smartmatic to win in Delaware and in New York, they have two cases, they have to pierce through the First Amendment defenses that a media company immediately puts up under a line of cases under the Supreme Court, New York Times versus Sullivan, which gives normal reporters, normal reporting, a broad insulation against suits like this, unless there is a showing of actual malice, a legal term that means you either know what you're saying or what you're promoting on your show is false, or you let it happen with reckless disregard for whether it's true or false. So that's what all these emails go to, that they have established this is what Dominion is arguing, that they've established by way of these internal emails into the inner mind, the real thoughts, the transactional thoughts of these big three and others like Rupert Murdoch, that they actually never believed what they were reporting, that Dominion voting machines committed election fraud. Its machines had software that flipped votes from Trump to Biden. None of them believed that, yet they let that go on the air time and time again. These emails go to actual malice, which would defeat a First Amendment defense.
I'll tell you what I think is going to happen, but first I will tell you what my opinion is. If Ben Meiselas was the judge presiding over the case and I got the emails and messages, I would grant the summary judgment here. I do not think the judge is going to grant the summary judgment. And this is probably a reason why I will never be a judge. I think what the judge will want to happen is to let this case go before a jury because it is tinged, even though I do not believe this should be viewed through a political prism at all. This is objectively a fight for our democracy. Nonetheless, I'm giving you the perspective of the inner workings of the mind of a judge here. And I think what a judge would feel is if I granted the summary judgment with the First Amendment defenses by Fox, one, there's a likelihood it could eventually be overturned. Two, I mitigate my risk as a judge from such a bold decision like that if I just throw it to the jury and let a jury ultimately make the ruling. And then three, there are those political considerations because judges are also, in many cases, elected officials in certain cases, and they get promoted based on political considerations. And we may like that or dislike that process. But ultimately, I don't think the summary judgment will get granted, even though I think it should get granted. I think there are no disputed facts here when you see the messages that this was intentional and malicious by Fox. But I want to get your perspective, Popak. I just want to read some of the messages, though, from Fox hosts and Fox executives. And this is what they were saying in text messages, emails, at their depositions about Donald Trump and Trump's supporters and the Trump supporters who were coming on Fox, who they were platforming to lie. Tucker Carlson, Sidney Powell is lying. Okay, that's what he said. Sidney Powell is lying. Tucker Carlson to his producer, Alex Pfeiffer, November 16th. Laura Ingraham to Tucker Carlson and Sean Hannity in text messages. Sidney Powell is a bit nuts. Sorry, but she is. Rupert Murdoch on November 19th, 2020. Really crazy stuff. This was in a deposition to Meade Cooper, Fox News Executive Vice President of Primetime Programming. Do you believe as of November 6th that going on television to say that the election is being stolen would be a conspiracy theory? Answer: I agree that would not be based in fact at that point. This is Suzanne Scott, the Fox News CEO, at her deposition. Question: you believe since at least the time that Fox News called the election on November 7th that Joe Biden was legitimately elected president of the United States, correct? Answer: yes, I believe that. And later in the motion, you see other messages from Susan Scott saying, early on in the process, we can't give these crazies an inch. But then they not only gave the crazies an inch, but they gave them the entire Fox platform. This is Steve Bannon to Maria Bartiromo, and Bartiromo is one of the individuals who spread massive amounts of disinformation. This was Bannon talking about the plan. Here's the plan you need to execute, Fox. Quote, 71 million voters will never accept Biden. This process is to destroy his presidency before it even starts. If it even starts, we either close on Trump's victory or delegitimize Biden. That's the plan. Steve Bannon, that's November 10th, 2020, to Maria Bartiromo. Then you have Fox reporter Lucas Tomlinson to Brett Baer. It's who's the Fox's chief political correspondent. It's dangerously insane, these conspiracy theories. And then Fox's internal fact check, incorrect, not evidence of widespread fraud. Look, no evidence of widespread fraud. Look, I could do 35 minutes or 40 minutes of this. In fact, I did. You could go watch the other video that I did where I read all of these messages. But as you go deeper and deeper into this motion, what you see is Tucker and Hannity were terrified that Newsmax were taking their ratings. They knew that the Trump crazies, and this is what they call them, crazies, were lying, but that they had to platform to keep their ratings and to keep the audience there. So they decided that they were just going to lie and lie and lie again. And then when you see just like when they talk about their sources, what the lawyers for Dominion were able to find out, like with respect to like when Sidney Powell would be platformed and talk about the sources that she had, it was like from an individual who claimed that the Wind, WIND, would provide the information through a spiritual process. And that's how they got their information. And then that would be platformed on Fox as a source that told them that information. I could go on and on and on, Popok, but I guess first, what do you make of my analysis of what you think the judge is going to do? And then let's get your overall perspective on this bombshell filing.
Yeah, and the ones that I found, I mean, it's funny. You and I could both read 200 pages, and two like-minded lawyers could find different things that you find fascinating that you want to summarize for the audience. For me, the driving force in the emails and text messages were that Fox News was worried, as you said, about losing ratings because once Biden won, all the eyeballs were moving over to CNN and MSNBC, and they didn't have a hook to keep their people. Their people were less interested. Fox viewers were less interested in hearing about a Biden presidency on a daily basis. So they needed to create and gin up a fraud, and they just used Dominion voting machines, voting systems, a companies nobody's ever heard of, and Smartmatic, who literally had one precinct that was their client in Los Angeles County. And they decided that they were going to sacrifice this company, club them to death on national television under the guise of quote unquote reporting. And no one ever believes Hannity, Ingraham and Tucker Carlson are reporters. And we'll talk about the difference in a minute and why they don't get First Amendment protection. But it was apparent. I'll give you the one example that I think you hit on your hot take. I know I did, is one of their Fox reporters, she fact-checked a tweet from Donald Trump attacking Dominion voting systems, the plaintiff in this case, and said on her own fact-checking, there is no evidence of Dominion voting systems having committed any fraud. So you'd think, okay, that's a good thing. Fox did that. No. Tucker starts to email the rest of the big three and say, please get her fired. She needs to stop now, tonight, and because she's killing the ratings. And that's it. The mask is off. This is the MO. This is the modus operandi. This is the motive for attacking Dominion and not caring about the fact that they were shutting down this poor company who did nothing wrong other than they needed a foil for their ratings. And you see just more of that over and over again. From a summary, to answer your initial question, I agree with you. Although Eric Davis, the judge here who sits on Superior Court, yes, there is a feeder program where the Superior Court judges often want to go one level up. It's seen as one level up prestige-wise, and go sit on the Chancery Court of the Delaware. That's the main business court where all the huge corporate battles happen, the Twitter cases and Elon Musk. It's really up the street at the Chancery Court. So a lot of them want to go there, or they want to go to federal court. But if he wants to go there, right, there it is political. But, I think that Fox News is in deep crap because they were unsuccessful in their ability to keep these emails secret all the way through trial. Fortunately, we had spoken last week or 2 weeks ago about whether Eric Davis in trying to protect the due process and the rights of all the parties was going to keep a lot of this out of the public domain prior to trial. The answer to that is no, and not everything was released to the public, but a lot was, which you've referred to. And the standard for summary judgment is there has to be an undisputed factual record, undisputed facts that support the claims, in this case, defamation, libel, and the like. Usually issues like actual malice, which is the new element that the plaintiff has to prove in this kind of defamation, which I don't have to prove if I'm just suing my neighbor for defamation because of the status of who people are. But here they have the extra burden, plaintiff does, to prove actual malice. Usually that's not able to be resolved on summary judgment, and you got to go right to a trial. But here, it's pretty compelling. Now, they could point, we're going to see the opposition papers in the next few weeks because, Fox gets their say as well. And they're going to point, I assume, to counterfacts that are now in dispute over the same emails. Excerpts from the other parts of the deposition that aren't being cited to throw into the mix, at least suggest to the judge that there are issues of material fact in dispute, therefore not ripe for summary judgment. Let's get to the trial in April. And it is very hard for a plaintiff on these types of issues. But look, if there's not a lot of counterfacts on, what 91-year-old Rupert Murdoch said to the head of news for Fox about this is wacky stuff, Giuliani's crazy, why are we platforming them? That's pretty damning going towards actual malice, and I'm not sure you need much else. The other interesting thing about all of this is that their argument is we're just reporting the crazies. We're not in bed with them, and that's not what other courts have found already. One of the appellate courts in New York in the Smartmatic case, a very similar case against Fox News, said, no, you're amplifying, you are promoting. Every time you have an ad that says, coming up next, watch Rudy Giuliani and Sidney Powell tear apart Dominion voting machines, the fraudulent company. The difference is if you and I are watching, I'm just throwing out a random one, you and I are watching NBC Nightly News. You can fill in the blank for any of your mainstream nightly newses. And, Lester Holt says, today there was a press conference involving Rudy Giuliani and Sidney Powell, at which they claimed that Dominion Voting Machines was a fraudulent company whose software flipped votes from Trump to Biden. Okay, that is probably likely protected, because there's no actual malice. If the next thing out of Lester Holt's mouth was, and I agree with that, I believe that is probably true, and that there's a lot of other fraud going on that we need to get to the bottom of. That's the difference. And that's what Fox News' personalities in their info newsotainment do every show. And that is why they should not enjoy, ultimately, the protection that a New York Times, Washington Post, fill in the blank enjoy, because they're not there as reporters. They're egging on their guests. They're selecting the guest with a viewpoint. They're putting them on, and they're leaving the impression that this is actual factual news, and they're allowing this poor company, and fill in the blank for the company, could be any company, to get bashed mercilessly and defamed on national, international television because they're worried about their own ratings and losing money. That, ladies and gentlemen, is punitive damages. That is actual malice, and they're going to lose. Now, the question, if Fox News isn't already in negotiations and discussions with the plaintiffs after the filing of the summary judgment, they better hurry up and get in there. Because if they think they're going to do better in front of a liberal-leaning Delaware jury, reminding people Joe Biden is from Delaware, okay? The Delaware court system skews, and the juries skew liberal Democrat. It has a huge African-American population. That jury is not going to be friendly to Fox News. And it could easily be, I know people like us to talk about our practices. I've seen juries, as a trial lawyer, visibly and physically manifest their dislike for a party by the way they lean away from the lawyers in the jury box. They fold their arms during arguments that are being made. They roll their eyes. And if Fox News thinks they're coming into some sort of friendly MAGA right-wing platform, they're not. This is a jury that is not going to be their friends and could hit them with a large. They think that's why I want to pick it up. Ask you a question, Ben. A lot of the focus of the public statements made by Fox, by their press people, focuses on not on the liability, but on the damages. They just think the damages are too high. Like, how could this little company suffer $2.7 or $1.6 billion worth of damages? Ha, ha, ha. You know what? If the jury wants to nail Fox News on a punitive damage model for a company that currently has $5 billion cash on hand as of its last reporting to the SEC, one of the ways you do it is you write a check for $1.6 billion that Fox has to sign in cash.
No doubt about it. And look, I mean, Dominion's economic model actually seems to me to be fairly normal. I mean, they are a company that has a lot of contracts with various municipalities. They were a thriving company. It will be easy to bring in an economist who is going to show where they were headed and where they are now, and that their name will forever be tainted because, these Republican areas can't really hire Dominion anymore like they used to. They'll be able to show the business loss that was caused by these conspiracy theories and that it really destroyed the name of the brand. It embroiled them in something because, as Fox admits, they platformed the crazies. They said, we're not going to give the crazies an inch. Newsmax started giving the crazies a platform. Fox says, oh, we're going to lose our viewers. We need to platform all of this disinformation. And it's basically what the Republican party's become as well. The Republican, it's like the primary process, right? If you look at Fox versus Newsmax, you almost think about it in terms of a Republican primary. So if you're a Republican and there's a candidate, let's call him Newsmax candidate, and you're the Fox candidate, and you go, I'm going to lose this election unless I believe in QAnon and unless I become an election denier and I have to call insurrectionists political prisoners, you're confronted with a test of leadership. And it actually should be a very easy test, because for you to get better ratings or more money or win an election should not require you to be a disgusting fascist traitor. You should look at Adolf Hitler, and you should look at Mussolini, and you should look at Kim Jong-un's, and you should look at the quest for power of despicable tyrants and despots and say, that is horrific. That is bad. You shouldn't look at that and go, that's a path to power. That's a little bit interesting. And the problem, the systemic problem that we've always had recently, though, that is being confronted, I think, as Democrats are starting to get more vocal, as the exhausted majority pro-democracy community is waking up, as we have more independent media, though, is that you had this instinct by large media networks to then kind of both sides it and say, well, here's a perspective and here's another perspective. And this is a conservative and this is a liberal perspective, versus calling out, whoa, that's some fascist, crazy, disgusting stuff. That's what needs to happen. It's happening more about it now. I will not give you the political lecture here on legal AF, but we will give you the legal one, which is this trial is something we will be watching very carefully and giving you detailed reports on. Another trial that we are covering very carefully here and continue to give you detailed reports on is one that's also set to go to trial in April. This one is in federal court in the Southern District of New York. It's E. Jean Carroll's federal civil lawsuit against Donald Trump for defamation and sexual assault. That's before Judge Lewis Kaplan, the presiding federal court judge there. And this week, the big news was that Alina Haba, who I guess is still on the legal team, last week we were saying they brought in a new lawyer, Joe Tacopina, who started making various filings in that proceeding. And Alina Haba seemed to be sidelined, but I guess Alina Haba wants to flex her muscles here and show that she's able to still file things. But she filed this really bizarre motion, which I think is going to be rejected fairly quickly. And it is to exclude evidence of other women who have accused Donald Trump of sexual assault in the past, as well as to exclude Donald Trump's own statements and, for example, audio recordings where he brags about sexually assaulting women, grabbing their genitals without consent, how he just kisses them and he can't resist, and he uses these horrific terms, and also Donald Trump's general kind of statements about women over the years as well. The argument in what's called a motion in limine filed by Alina Haba. And again, what's interesting too, and you pointed this out, Popak, in the hot take that you did, is that Joe Tacopina is not on this motion at all. But this is what's called a motion in limine, or a motion to exclude information at trial, with the idea being you can't unring the bell once a jury hears information. And so even if the information may be relevant, it is a test regarding its ultimate admissibility to balance the probative value of the evidence against its prejudicial nature. And so in this motion, Haba argues that the prejudicial nature of all of this, the other women in the past, outweighs the relevance to the jury. Popak, maybe break down a little bit what these allegations are against Trump and what you think the outcome of this motion will be.
Yeah, let me start with the return of Alina Haba. I thought she was buried in the crypt as radioactive. One, because she just went before the grand jury with Jack Smith to testify about her involvement with Mar-a-Lago and the documents and the searches there. And he's going to go try to rip the attorney-client privilege away from her on those issues, which is pretty bad. And of course, she got sanctioned for $1 million along with her client, Donald Trump, for filing meritless bad faith things. And she's in over her head, as we've reported in the past, in going up against Robbie Kaplan, the powerhouse lawyer, trial lawyer extraordinaire for E. Jean Carroll. And I thought all of that and the arrival of Joe Tacopina, not just as co-counsel, but he was identified as lead trial counsel. And that's what they reported to Lewis Kaplan. And that's what he considered himself to be, fighting with Robbie Kaplan and the judge over that DNA evidence or testing related to the now well-known black coat dress. So I'm thinking Joe Tacopina all day long, right? No more Alina Haba. Now, you and I have been co-counsels in other cases with other law firms. Have you ever, I'll ask you a question, have you ever in your career where you've been a co-counsel had your one of the lawyers that you're co-counsel with file a document on the court record and drop your name from it?
No.
Ever.
No,
right.
I've never,
right. And
I've
that's
never
my
seen
point. Right. It's never. Right. So I want to make this is where the insider stuff we like to talk about. Joe Tacopina is nowhere on the motion that was just filed. His name's not on there. He's not listed there. It's as if he just disappeared. Like we got to send out a search party and put him on the back of a milk carton. Where's Joe Tacopina? Because I thought he was the lead trial lawyer for a case that's going to trial in April, but you can't tell from the motion. It's almost as if they're saying, hey, I got to file a meritless bad faith motion that's a loser. Let me look around. Oh, I got the perfect person for this. Alina Haba, let her file it. And when I read the 21 pages in which they're trying to do two things, well, three things. All the crappy stuff he said about accusers that have come out that have said, me too, we've been sexually assaulted and attacked by Donald Trump. And it's not just the two women that we're going to put on the board now. It's not just the reporter for People Magazine and a businesswoman who sat next to Donald Trump on an airplane. We'll talk about them in a minute. But he had talked about on the campaign trail all the other people that came out, the Playboy models, the Miss America pageant contestants, people on Celebrity Apprentice, all of it. it's like Tiger Woods, dozens and dozens and dozens of women came out, and he would talk about them on the campaign trail in recordings. So they want to bring those recordings in, and all of his BS denials and macho, lies on the campaign trail. So that, of course, that's exactly the kind of stuff that would be really, really interesting to a jury to hear about, whether his behavior here and his denials here against E. Jean Carroll, in which he calls her a con artist, a fraudster, not my type. Has he ever done anything like that before? Is this a pattern and practice of his that the jury should hear about? And the answer to that is yes. So you have the presidential speeches. The next thing that the Trump lawyers want to keep away from the jury, which is exactly what should go to the jury, is the now infamous Access Hollywood tape that was done in the early 2000s, but didn't get disclosed until just before the second presidential debate in 2016 with Hillary Clinton. And that's the one with Billy Bush, where they were on a hot mic they didn't know about in the production truck, at which time he just starts talking. And I want to talk about the deposition where E. Jean Carroll's lawyer brings this up to him and what he says to her and her physical appearance next. Hold that thought. He and Billy Bush are just sitting shooting the breeze, and he says, "Yeah, when you're a big celebrity, you're a big star like me. I just like kissing beautiful women. I just go up and kiss them. I grab them and kiss them. You can get away with that when you're a celebrity. Sometimes I just grab them by the P word." I mean, this came out, and this became, if everybody doesn't remember, we'll put a clip somewhere on the Midas Touch Network, where during the debate it came up. And he said, "Oh, locker room talk. I never did those things. That was just me, shooting the breeze," or whatever he said. That actually pissed off, understandably so, at least two of his victims. And they've come forward, and those are the people, Natasha Stoyanov, the reporter for People magazine, whose testimony under oath in a video deposition in the case here says that when she was covering a puff piece for People magazine on Donald Trump and Melania's 1-year anniversary in Mar-a-Lago. See, it's all coming together now. While Melania was out of the room, Trump put her up against the wall, tried to forcibly kiss her, and said, "One day you and I will be in an affair together." Crazy stuff. She wrote about that crazy stuff in the puff piece in People magazine. She also claimed that she saw Melania Trump sometime after that on the streets of Manhattan on Fifth Avenue near Trump Tower. And that Melania said to her, and I'm going to do a terrible Melania accent, "Natasha, why don't we see you anymore around Mar-a-Lago?" Like she was the reporter, the beat reporter for the Trump family puff pieces, and she wasn't there anymore because she got sexually attacked. And that conversation, Melania hired a lawyer not to stop People magazine from running the story about her husband putting Natasha up against the wall and kissing her. She said, "I don't remember meeting anybody like that on the street." So typical Melania. Melania, faint praise damns Trump, right? Forget the part about the husband sexually assaulting somebody. "I don't remember meeting her on the street." Well, fortunately for Natasha Stoyanov, she had a girlfriend next to her who overheard the conversation. So there you have that. The second person who's going to testify, or at least going to try, and this is what they're trying to preclude her from coming in at trial, is a businesswoman who was upgraded, unfortunately, from economy class to first class on a flight back in 1986, Jessica Leeds. She said that 20 minutes into the flight, Trump pulled up the center armrest and started molesting her sexually, started touching her breast, trying to kiss her. And she told people contemporaneously at the time, including her then boyfriend, about what happened. So, that's another badge of honesty, badge of truth that shows that they're telling the truth. And of course, Trump hates that. He doesn't want another person coming in just like E. Jean Carroll. The other fascinating thing, or not fascinating is the wrong word, we should clip that in post-production, disgusting thing, is that in the deposition where Donald Trump was confronted with the testimony of these women by E. Jean Carroll's lawyer, Robbie Kaplan, he doubled down on the comments and made it sound eerily the same. For instance, when he brought up Jessica Leeds and about the comment about appearance, Donald Trump looked at Robbie Kaplan, a female lawyer, and said, in effect, "I don't think you're very attractive either. I'm not attracted to you either. Don't take that personal." So he was trying to, that was in retaliation for an earlier question that he didn't like from Robbie, where Robbie said to him, so this comment here about being a star or being celebrity and you're able to kiss women against their will, you consider yourself a star? You're able to do that? Yes, I consider myself a star, a celebrity. And then to pay her back, he decided to attack her looks and her appearance because that's who Donald Trump really is. All of this might have given him a little giggle with his lawyer out in the hallway during a break, but it's going to be up on a giant screen and video in front of a jury in New York who's going to have to decide whether he really did these things. When he went after Natasha Stoynoff, the reporter for People magazine back in 2016, he said eerily almost the exact same things that he says about E. Jean Carroll now. He said she was a liar, and she was, which is exactly what he said about E. Jean Carroll, con artist, liar. And he said, basically, look at her, she's not my type. He said, I look at her in her dreams or something like that. It was almost identical. So, we all know why they're trying to keep this stuff out. Now, the only balancing that Judge Kaplan's going to have to make here is whether, as you laid out, Ben, whether what we call the probative value, the relevancy, that it goes to the heart of an issue, is outweighed by unfair prejudice to the defendant. In other words, it'll blow the jury's mind. But I think they lose that balancing test. I think Lewis Kaplan rules to allow this in. He may give an instruction to the jury around these issues so that they understand how to process this information as the trier of fact. But when you read Alina Haba's filing, whatever that is, she not only is it really short on case law, because most of the case law goes against her in this area, and her analysis of the different rules is really pathetic. The primary focus is on a treatise, not on a series of cases. Treatises, for those that don't do this for a living, are like books and observations written by other lawyers about the law. Sometimes they're persuasive, but usually judges are like, where's the case law? Where's the case law that you're relying on for this particular issue? And so she's got beyond an uphill battle to win on any of these things. And I think Joe Tacopina, trying to preserve at least a shred of credibility in front of this judge who has eyeballs, who sees that Joe's not on this motion, is trying to get as far away and get behind a bomb shelter before the judge rules against them. Obviously, this is something that Donald Trump, the client, wanted his lawyers to do. My interpretation is Joe didn't really want to do it. So he took the lawyer that will do anything for him, and he made her file this motion. They're going to lose it. This case is going to trial. Leeds and Stoynoff are going to testify. The Access Hollywood tape is going to be played, and he's going to lose this case against E. Jean Carroll for civil rape and defamation. What about you, Ben?
I agree with you. Judge Lewis Kaplan has not made a single ruling in Donald Trump's favor this entire case. And not only that, in ruling against Donald Trump on essentially every ruling, has stated you're trying to delay, you're engaged in bad faith practices, you're trying to further victimize the plaintiff in this case. Stop it. That's what we see over and over again. I do not see Judge Kaplan in any way excluding this evidence, but we will keep everybody posted there. Still have a lot to discuss on this episode of Legal AF. We got to talk about how former Vice President Mike Pence is trying to avoid the subpoena by special counsel Jack Smith. We got to talk about how the terrorist Proud Boys have subpoenaed Donald Trump at their current seditious conspiracy trial, which is taking place right now. They took a brief break end of last week because one of the jurors was sick. And we got to also talk about this Fulton County special grand jury report regarding 2020 election interference, the 3 portions that were released, that is. But first, got to take a brief break from one of our sponsors. And here is your favorite Midas Touch brother delivering that message, Jordy Mycelis.
And now let's take a quick break to talk about our next partner, Miracle Made. Did you know that your temperature at night can have one of the greatest impacts on your sleep quality? If you wake up too hot or too cold, I highly recommend that you check out Miracle Made's bed sheets. Inspired by silver-infused fabrics made by NASA, Miracle Made makes temperature-regulating bedding so you can sleep at the perfect temperature all night long. Using silver-infused fabrics originally developed by NASA, Miracle Made sheets are thermoregulating and designed to keep you at the perfect temperature all night long so you get a better sleep every night. These sheets are infused with natural silver that prevent 99.9% of bacterial growth, leaving them to stay cleaner and fresh 3 times longer than other sheets. No more gross odors. Miracle sheets are luxuriously comfortable without the high price tag of other luxury brands. Stop sleeping on bacteria. Clean sheets means less bacteria to clog your pores and fewer breakouts and other skin problems. Go to trymiracle.com/legalaf to try it today. And we've got a special deal for our listeners. Save over 40% off and be sure to use our promo code LegalAF at checkout to save even more and get 3 free towels. And Miracle is so confident in their product, it's backed with a 30-day money-back guarantee. So if you aren't 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/legalaf and use the code LegalAF to claim your free 3-piece towel set and save over 40% off. Again, that's trymiracle.com/legalaf to treat yourself. Thank you, Miracle Made, for sponsoring this. And now, back to the video.
Thank you, Jordy, for
Can I say one thing about that before you move on?
Of course.
Jordy does the ads with our sponsors so authentically and so earnestly that I already have this stuff because, you know, I buy them to try them. I want to buy Miracle Made again off of that last read.
That's why Jordy's the Jordy ad man mycellus. Let's get into the former Vice President Mike Pence and his objection. He's gone on a self-flagellating tour with Mother this past week and talking about how the real
Did you just say Mother?
Yeah.
Okay,
how the real important issues here, Michael Popok, as a Christian, as a conservative, and as a Republican.
And he calls his wife Mother.
He does. I have a solemn obligation based upon those 3 things to stand before you all and say the most important thing here when I think about January 6th is the separation of powers argument embedded in the speech and debate clause.
They almost separated his head from his neck. Speaking of separation.
Michael Popok, here's the thing. As a Christian, as a Republican, and a conservative, here's the thing. If you want to behead me, if you set up the gallows, if you set them up outside and you say, kill Mike Pence, what I'm going to have to do is say, are you a Christian? And are you a Republican? Because if those 2 things match, I will say, take my head, take the head of my family members. You are a Republican, and this is important in our Constitution.
If it's a rally, I'm there. If it's a Republican rally, I'm there.
Any chance for me to do my Mike Pence impression?
And you're doing facial too. People, the YouTubers will really appreciate it. You're not only channeling the voice and the timbre of Mike Pence, but now you're doing, I don't know if you realize you're doing it, you're doing facial. You're like your little eyebrows and the way you're squinting. It's uncanny.
So here's the most important thing about to Mike Pence is to now claim that he is actually not the vice president, but that really his powers emanate from Article 1, Section 6, Clause 1 under the speech and debate clause, combined with Article 1, Section 3, Clause 4 of the United States Constitution. His ceremonial roles as the president of the Senate to him makes him a senator, and therefore the speech and debate clause, which protects testimony, for legitimate legislative activities, as it's been interpreted by the United States Supreme Court with the seminal case of Gravel versus the United States, that immunizes him from having to testify about anything leading up to the insurrection and the insurrection itself. So just if we look at Article 1, Section 6, Clause 1, what it says, this is known as the Speech and Debate Clause. This is what Pence is citing. The senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the treasury of the United States. They shall, in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place. It's really that last part of this clause. And for any speech or debate in either house, they shall not be questioned in any other place. But then we go to Article 1, Section 3, Clause 4, which also says the Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. So Pence's whole argument, you read these two clauses together, I'm like a senator, and therefore the speech and debate clause immunity applies to me. Now, a few observations. Number one, what? Okay, number two, I'll give you the legal analysis, though. Look, the speech and debate clause doctrine has been expanded over the years. It doesn't just apply to members of Congress, the members of the House of Representatives or senators. It also applies, for example, to their legislative aides. And it doesn't just apply to statements that were made on the House floors in the respective chambers or the floors in the respective chambers. It also applies under Gravel versus the United States to legitimate legislative activity that takes place outside the House chambers as well. For example, like legitimate legislative fact-finding would be an example, or committee meetings that take place outside, or there is a question open, outstanding amongst legal scholars, would independent or informal fact-finding also be constituted under the speech or debate clause privilege? But in Gravel versus United States, they also made very clear that there are exceptions. Statements that are made to the public and statements made to the press are not subject to the speech or debate clause privilege. Also, non-legislative activity, as well as illegal conduct, exhorting, cajoling, threatening people, that would not be legitimate legislative activity. So there are exceptions to the speech and debate clause that are recognized in Gravel versus the United States. So here, my analysis, then I'll get yours, Popak, is as a threshold issue, number one, does Pence even get to claim based on this quasi-legislative role for a vice president, that he's even entitled to the benefit of the speech or debate clause? I think he shouldn't be, but assuming that he is, you go to the second part of the analysis here, which is, when does the speech or debate clause privilege apply? To me, if it applies at all, I don't think it should apply. It should only be while he has that ceremonial role, while he's actually there counting the votes on January 6th, not to all other conduct. But then you get to another inquiry, which is that it only protects legitimate legislative activity, and observations about ongoing criminal conduct by Donald Trump does not constitute, in my mind, or in the mind, I think, of any legitimate legal scholar who should care about these issues or who has a brain, that should not constitute legitimate legislative activity. Finally, statements made to the press and PR are not subject to speech and debate clause privilege. And Pence has written a book. He's spoken to the press. And so I could approach it, I think, if I'm Jack Smith, from that angle as well, which is, hey, I want to ask you about your statements to the press. That's a recognized exception under Gravel. So, so at the end of the day, do I think that with the current composition of the Supreme Court, can Pence possibly assert some variation of this? I don't think he should, but I think that special counsel Jack Smith with the scalpel should try to really narrow it and say, look, even if you accept this premise, which we don't, it will only apply to this instance. but not all the conversations leading up to the insurrection, not the communications about unlawful conduct that Donald Trump was engaged in, not the press statements. And I think Special Counsel Jack Smith's absolutely going to fight that and continue to fight that. But it just shows you the roadblocks and the hurdles and the complexity of the legal issues at play here, because when you give people like a Pence or a Trump the keys to these really awesome powers that everyday citizens can't make a speech or debate clause privilege claim. They can't make executive privilege claims. And people who truly hate our country, like Pence and like Trump, can manipulate and use that in ways that are very harmful, not its intention. And how many times have we now said on this show and elsewhere, this is the first time that this has happened? It's because what is unprecedented is not that a former vice president is having to be subpoenaed by the Department of Justice. What is unprecedented, let's not gaslight ourselves, let's not be gaslit, is that a former president tried to have a violent coup to overthrow our democracy, to terminate our Constitution, and to declare himself a king or an emperor. So this isn't all a disagreement amongst conservatives and liberals. No, this is a fascist coup that was foiled, thankfully, and a need for a pro-democracy civilization to gain accountability. Popok.
Yeah, let me focus on a couple of things in that. The other code section we got to look at is 3 USC code, 3 USC section 15, which is the Electoral Count Act, which defines what the vice president's totally ceremonial role is. Literally, envelopes are opened up in front of him, and he nods ponderously and then bangs a gavel and declares the total, right? Arithmetic is done in front of him by a clerk, and he just says, seems right. That's it. In fact, it is so ceremonial, so non-legislative, so not being a legislator, that even his own lawyer, J. Michael Ludwig, who is the really conservative Republican father of many of the law clerks and even Supreme Court justices in terms of jurisprudentially, he ended up being, at the last minute, a counselor to Mike Pence through his general counsel, Greg Jacobs, when Eastman and Trump were putting tremendous pressure on Mike Pence to, quote unquote, do the right thing, to implement the fake elector strategy and scheme, to not certify the election on Jan 6, to put it off 10 days or more in order for state legislators, mainly Republican, to come up with these fake elector certificates and send them in and throw it over to the House of Representatives, take it away from the will of the people, and let the primarily Republican state legislators, elect our president. That was the scheme. In order for that to work, Mike Pence, as the last line of defense, had to go along with this. And so Mike Pence refused to do that. And to get some courage, to get some gumption, to get some legal advice, Greg Jacobs brought in at the last minute this former well-regarded Republican federal judge, Ludwig, who told Mike Pence, you cannot do the John Eastman plan. It is unconstitutional. It is unprecedented. You will go to jail. That is a coup. And relying on that, Mike Pence said, I won't do your impression. Mike Pence says, this I cannot do. I have a job to do. It's one thing, and it's ceremonial, and it is just to certify the tally made by the clerk of the electoral votes, and that's all I'm going to do. There's a lot around that Mike Pence, not as part of the legislation or legislators, he's not a legislator. He is not. He is a constitutional officer. He is the vice president, and he has powers related to that, and he does have this other tie-breaking power, but that does not mean he gets the benefit of having, as you said, the protection of speech and debate, which goes to allowing people who are making law and those that work for them to do so without being hauled into court or being examined by another branch of the government. It kind of keeps everybody in their lanes in the co-equal branches of government that we have in this country. What he refers to as separation of powers, but it doesn't fit here when he's not serving in that role. I mean, I took a White House tour once and I got to see the White House, but that doesn't make me the president and I don't have his powers. And that's sort of where we're at with this. The interesting thing about it is most people that have a brain in their head, like J. Michael Ludwig, who was the lawyer for Mike Pence, has said Mike Pence is wrong about objecting to the subpoena. Even his own lawyer says he is wrong putting up speech and debate and any other separation of powers not to testify in front of the grand jury about the pressure that was put on him by Donald Trump as part of the John Eastman scheme and the fake elector scandal. The testimony that we already know from the Jan 6 committee that a Secret Service officer tried to get Mike Pence into a car and whisk him away from the Capitol and from his constitutional duties, and he refused to get into the car. He needs to testify about that. He needs to testify about conversations he had with Donald Trump about this coup in search of a legal theory, as you like to call it. He has to testify about that. We've already had a dress rehearsal for these very same arguments with a real senator in Lindsey Graham. Lindsey Graham, when he was pulled and compelled to testify in Fulton County for Fani Willis and her special purpose grand jury that we're going to talk about a little bit later today, he also threw up speech and debate. At least he had a colorable argument that he is part of the legislature and he is a senator. Now, the judge didn't buy the argument that he has this blanket speech and debate clause privilege immunity, which is what Lindsey Graham was saying. He said, no, for certain of the things you did, the phone call to try to find ways to throw out properly cast mail-in ballots in Georgia, like all that stuff and other conversations you might have had with the Trump campaign and the Trump officials, you're not making law. You're not part of the legislative process. You're outside of that. And so go testify. And on question by question basis, the judge said there, I'll be available to decide whether the speech and debate clause is applicable. He took that up to the 11th Circuit and the U.S. Supreme Court, and they said what she did was fine. This is how it's going to come out with Mike Pence. This is going to be a loser argument that's brought in front of first Beryl Howell, at least for another couple of weeks while she's still the grand jury chief judge until she's replaced by seniority by the next judge, Jeb Boasberg, who's also a Democratic appointee by Obama, so we shouldn't worry too much. And if he doesn't like the result there, he's going to take it to the D.C. Court of Appeals, where he's not going to have a favorable audience either. And if he doesn't like it, he's going to try to get the right-wing majority of the U.S. Supreme Court to rule in his favor. We have a lot of trepidation about the U.S. Supreme Court in most matters, and for good reason. However, when it relates to presidents and vice presidents' testimony and power documents, they basically have sided every time with the Department of Justice. Now, we'll have to see as this thing plays out. But based on the precedent of Lindsey Graham and how that worked its way through the court system, Pence is going to lose. Pence is going to have to testify. He doesn't have that privilege. They'll have a fight about executive privilege. Maybe they have a fight about attorney-client privilege, although I think he's now waived that in a number of ways. But he's going to testify, and it's going to be in the next 4 to 6 weeks.
Yeah, I think that Pence is going to fight it. It's going to go to the D.C. Circuit Court of Appeals. We'll probably be talking about an emergency application filed before the United States Supreme Court. The United States Supreme Court's going to do what they've previously done, which is going to make everybody really upset at the United States Supreme Court, though, because they're going to give a period of time where they're going to stop the testimony of Pence from taking place while they receive briefs from the Department of Justice as well as from Pence's lawyers. And then ultimately they're going to make a determination there. And I think that it's going to look a lot like the ruling that we saw in Georgia, which is going to be ask certain questions are okay, certain questions, try to avoid. And then Pence can make certain objections at that point in time. And then Pence will try to drag it out again. Ultimately, the Department of Justice is going to get what they want. But these are one of the tactics of coward, traitor, fascist. There's no other way I can say it. Like this is very cowardly. It's just cowardly, cowardly, cowardly. Because even as a reporter asked Pence, why wouldn't you just voluntarily want to tell the truth? You wrote a book about it. Why not just go under oath to help our democracy? And then I do the impression of Pence, though, where Pence says, well, the really big thing here is the separation of powers. No. And then when they go, oh, we love our Constitution. No, you love manipulating the Constitution. You love that the Constitution can be malleable based on your interpretation. If you don't like that the Second Amendment says a well-regulated militia, let's just pretend that it doesn't say that. And let's just read the right to bear arms. Let's take out well-regulated militia. And then let's say the right to bear arms means that everybody gets an AR-15 regardless of any training. Check the box. That's what we get because of the gun lobby. Let's just manipulate the Constitution there. Wherefore, states' rights here until we actually want to make sure that we can control the bodies of women and tell you who you can marry. In that case, we want the government, the federal government, to step in, and big government can control a woman's body, control who you marry, control your day-to-day activity like a fascist state. So we're for it when it's for us. We're against it when it's against us. And that intellectual dishonesty is really problematic when you are trying to approach it from a prism of intellectual honesty and consistency when you have people who constantly lie and gaslight. And I could go on that.
The thing about Pence that I always find maddening is he thinks it's enough to stand in front of a press conference and say, I've already said everything I need to say about Jan 6. Trump was wrong. I didn't have that power, and it was a dark day. Let's move on. No, that's not enough. We've got a criminal investigation about a former president at the time, who tried to commit a coup. You were a lead fact witness who observed many of the aspects and elements of it as outlined by the Jan 6 committee. And now you're going to have to, you have to take the good with the bad. And now you're going to have to sit in a box, swear under oath on that Bible that you love so much, look the grand jury in the eye, and testify honestly about all the things that went on. And no, you don't get the benefit of just take my word for it. He was wrong and I was right and I did the right thing and let's move on. It's not enough. That's not a criminal prosecution, and that's not how our criminal justice system works, where no one is above the law, certainly not the President of the United States.
Speaking of which, the terrorist group, the Proud Boys, they're currently engaged in their seditious conspiracy trial. This is the third seditious conspiracy trial brought by the Department of Justice in connection with the January 6th insurrection. The Oath Keepers won, number one, not WO, and they lost. And the two top Oath Keepers there in the first trial were convicted of seditious conspiracy. In Oath Keepers 2, Oath Keepers Trial 2, all five of the Oath Keepers were convicted of seditious conspiracy. Now, this is the Proud Boys staring down those same seditious conspiracy charges, in addition to all the other felony claims that all of the other terrorist groups were charged with and mostly convicted of on each and every one of those felony counts as well. One of the Proud Boys here in this case, Joe Biggs, his lawyer, and the other Proud Boys said that they wanted to send these subpoenas. So the fact that Biggs is doing it doesn't mean that the others don't want to do it. So just the Proud Boys generally are subpoenaing Donald Trump, though, and their lawyers are basically saying, look, the Department of Justice is essentially essentially saying Trump was a criminal co-conspirator here. They showed the Trump debate in the opening where it was the Proud Boys stand back and stand by. We have all this evidence of Trump's links with the Proud Boys, so we want to call Trump in our case. So they sent out a subpoena. There's the subpoena for those watching, for March appearance by Donald Trump to give enough time for this subpoena to be served. Ironically, the Proud Boys said that we'll rely on the government for help serving Donald Trump. So we'll let you know if service is effectuated, but the subpoena has been prepared. This isn't the first time that a insurrectionist trial they've tried to subpoena Donald Trump, but to be honest, though, on this one, it feels like they actually have the best shot at it. I don't know if, what Judge Kelly, the federal judge presiding over it, is going to do here, but let's remember that there's lots of links between Trump and people like Enrique Tarrio and Joe Biggs and some of the other Proud Boys who are being tried here. Look, Enrique Tarrio went to the White House and got a very special tour on December 12th, of 2020, like right before the January 6th insurrection. And he posted it on his social media platform and said, I got this unexpected invite. And he got to be in places in the White House that normal people, almost anybody, including dignitaries, don't get to see when they do White House tours. Like he was in the residence. He took a photo on the balcony of the presidential residence and took a photo right at the front of the White House. And the way I've described it on another one of my hot takes, though, is imagine Bill Clinton inviting Timothy McVeigh to the White House before the Oklahoma City bombing. And to me, it is that serious. I mean, or after, but the analogy to follow here, though, is that this was before the January 6th insurrection. It was undisputed that Enrique Tarrio was a terrorist. It's undisputed that the Proud Boys is a terrorist organization. And here's the thing again with the both sidesism. Like the Proud Boys are not conservatives. Okay, they're not like these are like Republicans and conservatives. They know that these are terrorists. These are terrorists who want to overthrow our democracy. And it is disgusting. It is sickening to have these individuals at the White House, to have Enrique Tarrio at the White House before. And then the Willard Hotel, which is a 5-star hotel in Washington, D.C., leave it to MAGA to totally defile that historic hotel right by the White House. But they use that as home base for the January 6th insurrection.
I'm glad it wasn't the Hay Adams. I like the Hay Adams Hotel.
Right. And they had, a lot of people in there in Trump's inner circle who were communicating with the Proud Boys and had direct communications with them. And then the Proud Boys even showed up at the Willard, so there's all those connections. So to me, it doesn't seem like a frivolous request like that. To me, there still is going to be the question of, is Trump a necessary, witness here? And ultimately, is it, is it just going to be a distraction? Is it admissible? But if anyone's got a shot, I feel like there's a valid reason why they want to subpoena Donald Trump. What do you think?
All right. Well, let's talk about this. First of all, let's talk about the process of issuing subpoenas. Officers of the court, lawyers, are allowed to issue subpoenas. It doesn't mean that it's the judge has blessed it. It used to be back in the day, clerks of the court had to issue subpoenas, but in federal practice, any lawyer in a case can attempt to issue a subpoena. Just means have it typed up. We showed a picture of it. Then you got to get it out and have it served. In between, we know the Department of Justice is going to object to this subpoena and move to quash it even before service. It's the one place they're going to be on the same side as Donald Trump, because they do not want the circus of Donald Trump being brought into a courtroom, which I don't think will ever happen in this particular case, because it's really irrelevant to to the prosecution, of course. The fact that they thought they heard Donald Trump tell them to do something as a motivation or as a defense to their mens rea in front of a jury, I think is a losing argument. You're going to see a strong motion filed by the Department of Justice to quash this subpoena so that it never sees the light of day and certainly never gets into a process server's hands to serve on Donald Trump. As you said before, others have tried this strategy and all have failed. Dustin Thompson, who got arrested and walked out of the Senate chamber or the House chamber with a stolen bottle of booze and a coat rack. He tried this, and the jury came back in 2.5 hours and convicted him of every count, and he was sentenced for 3 years in prison. Now, let's talk about for a minute the lawyer that's doing this for Joe Biggs. This is being issued by Joe Biggs's lawyer, Norman Pattis. Norman Pattis, a very well-known criminal defense lawyer in Connecticut. You may remember him because we've talked about him on prior podcasts. He's the lawyer for Alex Jones in the Sandy Hook trials in Connecticut. And he got severely sanctioned by the judge for allowing secret and medical information of the parents of the Sandy Hook children to go out to people that were outside the scope of the protective order. She ordered him, without going through a bar committee or anything, she ordered him as a punishment suspended for 6 months for that bad behavior. In fact, he just got his suspension stayed by the Connecticut Court of Appeals, or the Supreme Court in Connecticut, just 5 days before he appeared in court in front of Judge Kelly in the Proud Boy case to file this subpoena. He had been gone for most of this trial and sitting on the sidelines because his license was suspended. So on the 13th, the Connecticut court lifts the suspension for now while they let a full appeal go forward. He pops into court, mentions in court casually, I'm thinking about subpoenaing Donald Trump. We're working on it right now. And then here you go. It's a sideshow. Norm Pattis is known for this. He takes very, very unlikable, cringy type defendants. I'm okay with that in general. Every criminal defendant needs a lawyer, but he seems to relish becoming the focus of the trial himself. He does outlandish things. You know, for instance, in the just to remind everybody, I think you and I talked about this, Ben, in the Sandy Hook trial, he tried to subpoena Hillary Clinton. So this is a page out of Norm Pattis's book to kind of get attention, take it away from his clients, have some sort of fist fight with the Department of Justice, which he thinks he wins even if he loses. My prediction, it's going to get quashed. Judge Kelly's not going to let the subpoena go out ultimately. Donald Trump's not coming into the Proud Boys trial. They're going to get convicted based on the overwhelming amount of evidence against them that establishes that they committed all of these crimes, including from their own social media, from their own video evidence, from their own, what they thought were confidential communications that are going to be put up on the board and up on the video screen in front of the jury, just as it was for the Oath Keepers 1 and 2. And they're going down here as well. And that's the last time that Enrico Tarrio, we're going to have to think about him going to Mar-a-Lago for dinner, because he's going to be in an orange jumpsuit for a long, long time.
Well, and next week you have Jeremy Bertino, who should testify, assuming that the jurors feel better. And Jeremy Bertino was the leader of the North Carolina Proud Boys chapter, who has already pled guilty to seditious conspiracy, who was part of this group, who will be testifying against the group, who is on their confidential, they thought were confidential encrypted chats, which are not confidential. And he has all the information. And so his testimony should be devastating when that occurs next week or the week after, if there are still some jurors who are sick. And finally, let's talk about the Fulton County Special Grand Jury Report. Portions were released earlier in the week. We talked about the judge who had been supervising the special grand jury, Judge Robert McBurney, who I think's been doing a very, very good job here, very even-handed in the approach, has made some rulings that also were critical of the district attorney in some senses, but ultimately allowed the process and witnesses that had to testify. There was no gamesmanship here. The judge didn't put himself above the process. Like, the judge did everything right, including this decision, I believe. So earlier in the week, Robert McBurney basically said, look, there are, the statute in Georgia says that if the grand jury, the special grand jury states that they want this published, under Georgia law, it says shall. It says, I shall make it public. However, we need to balance that against the due process rights of individuals whose names may be mentioned in the report, who the Fulton County District Attorney Fani Willis says that indictments are imminent. And we want to be very careful and protective of the due process rights of individuals who may be indicted, who some maybe who have shown up before the grand jury, special grand jury, and others who may not have even had the opportunity to go before the special grand jury. For example, right here, for those watching and for those just listening, I'll read for you a portion of McBurney's order regarding these due process considerations that he issued earlier in the week. He said, look, these due process concerns are particularly true if the grand jury's final report includes recommendations involving individuals who never appeared before the grand jury and so had no opportunity, limited or not, to be heard. And as I said, that seems to be a reference to Donald Trump, because there were 75 witnesses who appeared before the special grand jury, including most people in Trump's inner circle other than Trump. And there's lots of speculation that one of the names in the report that Fulton County District Attorney Fani Willis was presenting evidence against and who the grand jury recommended be indicted is Donald Trump. So in many senses, the decision to not release the full report, but only portions of the report that don't release the names of the individuals who are recommended to be indicted, the introduction, the conclusion, and ultimately Section 8, in many ways was to protect the due process rights of people like Donald Trump and others. However, that was, of course, twisted by Donald Trump in a way that he said, let me inject disinformation into the process. Before we put up the post that Trump had, though, one finding that was published in the special grand jury report, though, is that they found by a unanimous vote, there were 26 members that composed the special grand jury. There were 3 alternates, but all voted that with all of the evidence presented, there was no election fraud in the 2020 election in Georgia capable of overturning the results there. So the only finding that has been made public was a direct rebuke of Donald Trump's disinformation and conspiracy. But Donald Trump posts complete exoneration. Let's show the post that Donald Trump made. Thank you to the special grand jury in the great state of Georgia for your patriotism and courage. Total exoneration. The USA is very proud of you. On the one hand, Donald Trump is doing this to inject disinformation, to use the due process considerations that he's been afforded, or that the other people, if his name's not in it, I think it is, but the due process considerations that other people who are being recommended for criminal indictments have been afforded, to basically say, look, my name's not in there at all. I've been exonerated, when actually this was done to protect his due process rights. He wants to destroy our Constitution, but he wants to also use our Constitution's protections to inject disinformation for his ultimate goal of overthrowing it. But I think something else is at play too here. And I've said it before on a hot take, and I've said it before, I think, on the political beatdown show I do with Michael Cohen. One of the reasons Trump employs this tactic, though, also is because his name is likely in it. He wants there to be a leak, whether it's the Fulton County DA or a member who was on the special grand jury who gets pissed off at the disinformation that Donald Trump states. So then it gets out somewhere. There's a report or a leak or something that happens where someone says, no, Trump's name is in the report. He's lying to you. He wants to bait that to happen. And why would he want to bait someone into saying, no, your name's in the report? So he could play the victim, because that's what they love to do in MAGA Republican world. And then they want to go and say, oh, you see, the judge was trying to protect the due process rights, and now you violated the judge's protections of my due process rights, so I can't be convicted, or you need to overturn my conviction if it is convicted. That's the tactic of these victim mentality of a MAGA Republican, the disinformation, as well as trying to bait that to happen. So they can go, oh, woe is me, woe is me. Just pull up another one of Donald Trump's posts, though, where he claims that these were the most important sections when they were not. They were the least important sections. So Trump writes, the long-awaited important sections of the Georgia report, which do not even mention President Trump's names, have nothing to do with the president because President Trump did absolutely nothing wrong.
How about when he talks about himself in the third person?
Right. I mean, in this one, just every sentence has like 3 times where he does it. And he's not the president. The president participated in 2 perfect phone calls regarding election integrity in Georgia, which he is entitled to do. In fact, as president, it was President Trump's constitutional duty to ensure election safety, security, and integrity. Then it goes to the next one. Between the 2 calls, there were many officials and attorneys on the line, including Secretary of State of Georgia, and no one objected, even slightly protested or hung up. President Trump will always keep fighting for the true and honest elections in America.
That's a lie.
Every single thing there is a lie, from the fact that even calling himself president, saying it's the most important sections. These were not the most important sections. He was absolutely not exonerated. On the phone call, they were objecting to it. They were telling him, what are you talking about? We can't do that. You are wrong. And then Donald Trump's last point is, because they didn't hang up the phone on me, that's why it was a perfect call. Who calls a phone call a perfect call? Like, this is here's the thing too, where it's like the gaslighting of large media networks too. Like, this is a maniac. Like, this is a fascist maniac, weird traitor. This isn't a politician, right? Like, this is a poisonous, cancerous, destructive force. This is no different than if Vladimir Putin was living in Florida and posting and wanted to run for office in the United States of America. You know, we cannot blind ourselves to what this is that we're reading. And I don't think, other than on the Midas Touch network, other than on Legal App for our, I don't even think it's being covered. I don't even think it's being covered. How do you not cover this, Popok?
Yeah, first of all, it's not a thing that if the party that you are extorting doesn't, quote unquote, object or hang up the phone, there's no crime committed. Another thing that Donald Trump has made up. First of all, he's wrong, because Raffensperger and his general counsel did object to being shaken down on the phone call by Donald Trump in a classic case of election interference. But that's not a thing, okay? That's not a thing that, well, they didn't object, so it was a perfect phone call, no crime was committed. I think your outline of what happened with these 3 relatively minor sections of the grand jury report, that in balancing the Chief Judge McBurney, or Judge McBurney's duties and responsibilities to protect people in the due process, especially unnamed people, from having their rights violated in advance, balancing that against the shall publish requirement of a document like the special purpose grand jury's report, I think he struck the right balance. I think he kind of gave a little bit of, threw a little bone to the media who were seeking to have the entire report released, and balanced that against what his prosecutor, who he reminded everybody in his order, that report, the special purpose grand jury report, that wasn't for me. That wasn't for the judge. That was for the district attorney. And there's only one physical copy of it, and that's with the district attorney. So this isn't a public document in that sense, but I do have to listen to the will of the special purpose grand jury, and I'm going to give these 3 relatively minor. And when we say relatively minor, because it doesn't list the charges, it doesn't list the people, it just talks about somebody committed perjury, maybe more than one person. And Donald Trump's like, well, it wasn't me. I didn't testify. So that's one place I couldn't have committed perjury. And he, like you said, he writes what he writes. But here's the thing. I agree with you that he's baiting and goading and trying to get somebody to step out of bounds and violate the secrecy of the grand jury process. I'll tell you who it's not going to be. It's not going to be Fani Willis. Fani Willis issued a one-line press release after she read Judge McBurney's order and said, yep, seems like a very prudent thing he did. We're not going to appeal. Okay. Now, the media's got to decide if they're going to appeal. Because the media is the petitioner that actually sought to have this released. They could appeal to the next highest level appellate court in Georgia and have them decide ultimately whether the entire report needs to come out. But I think this is going to be a very stale, much ado about nothing argument, because I think this will put an accelerant on the decision, the tough one, a hard one, but one she gets paid to do, that Fani Willis is going to make in the coming days, week, to move for an indictment, to go in, as you said earlier, I think we did this on our midweek edition this week, she may already be presenting to a regular grand jury this report and bringing in some live testimony to get her indictment. I don't think so. I think she would announce it. She's announced everything else. She announced that she hadn't made her decision, how she was going to make her decision, that she was going to have a special purpose grand jury, that it was going to be for a limited duration in time, that it issued its report. She's given us the TikTok all along the way. And one that McBurney has required her to do now in his order, which was, I want regular reports. It may not be public, it may still be confidential, about the pace of your investigation and your prosecution decisions. But I think she stands in front of a podium and announces that she's going into a regular grand jury with under her arm this huge report with all the evidence already there, which is proper hearsay that she can bring into a grand jury in Georgia, as opposed to other places like in New York, where you got to do it all by live witnesses testifying as fact witnesses who have knowledge. In grand jury Georgia, not the case. She can bring in the report, have excerpts of it read out loud, have testimony, prior testimony read out loud. I think she brings in, and Karen Friedman-Agnifilo, our co-anchor on Wednesdays as a former prosecutor, agreed that she's probably going to bring in a couple of live witnesses just to spice it up and get the jury to pay attention, the regular grand jury. But I think she announces she's going for indictments. And I don't know if it's going to be our midweek edition or it's next Saturday, but I think, by early March, I think she's going to move to indict, whether it's for election fraud interference or the bigger civil RICO, Racketeering and Corrupt Organization Act, mob type case that she's very skilled at doing. Then she has experts on her bench at the prosecutor's office who were brought in just to be civil RICO prosecutors. So she likes using this type of technique and tool. I think you and I are going to be talking about, and it's not if, it's when. And I think this moves the clock closer to midnight for her decision that she's going to announce to seek the indictment of people, including Donald Trump. What do you think?
Well, in terms of when, back on January 24th of 2023, Fani Willis told Judge McBurney, quote, decisions are imminent on the charges in Trump's efforts to overturn the results of the 2020 election. And to me, the word imminent means, as it is defined, about to happen. That's what imminent means. So about to happen then, we're now February 18th of 2023. And so if imminent means about to happen, then that should be happening soon. And I think Robert McBurney even hinted at that. And Robert McBurney, I think, held off really making this order until he had to, and releasing it until he had to, like, okay, you said it was imminent. I'm going to wait a little bit. All right, I'm going to release these portions. And then at the end of the order, that McBurney said, basically, keep me updated, because if things change, let me know. But to your point, Popak, I think imminent means February. If you said it in January,
I agree with you.
It means March. It means April. It means April, the latest.
Yeah.
But when you and I do these reports, we follow the data. And so when a data point of the word imminent from a district attorney who's been an honest broker with her words has a meaning that formulates a our projections.
And he's going to
so-
release more of this report. You know, he's parceling this out. He's spoon feeding it out. As
Yep.
you said, he's giving her a lot of line to run with here because he respects the district attorney and the process. And he's trying to balance these competing interests of due process rights of potential criminal indicted defendants and the rights of the prosecutor and the public's. I think, as you said, he's doing a great job. But he's made it clear in this last order that he's going to dole out more and make more of this report public until it's all public. Eventually, we're going to see the entire special purpose grand jury report. I think it's probably after she sought her indictments and we know exactly who's indicted and who isn't. And he may do some redaction, some black tape along those pages. But you and I are eventually going to see that report. We're going to have a whole show, special show, just on that report and what it reveals.
Yeah, in Judge McBurney's report from earlier in the week, in footnote 2, he says just that. Look, when indictments are made, when there's the normal process of criminal discovery, the report is going to be released in full or as fulsome as it can, balancing the due process rights. But we're going to get this report eventually, and we're going to get this report this year. I mean, just a matter of when, and we will keep you, of course, informed if there is any breaking news that we learn regarding the charging decisions by the Fulton County District Attorney Fani Willis, and that could be imminent, using her words. A lot of imminent breaking legal news this past week, a lot of breaking news that will definitely be occurring next week. We appreciate everybody who watches Legal AF. Want to make sure to remind you to subscribe here on our YouTube channel. We are on our way to 1 million subscribers. The month of March will be the March to 1 million subscribers. I think we will be able to get there at that time. But if you're not subscribed, hit subscribe right now and recommend to a friend, family member, coworker, or colleague to subscribe to the Midas Touch YouTube channel right now. Also, please take 2 minutes out of your time after this episode to subscribe to Legal AF on audio podcast as well. If you're listening to this on audio, take 2 minutes out of your time to subscribe to the Midas Touch YouTube channel. But for our YouTube viewers, please, right now when the show is done, search Legal AF wherever you get your audio podcast, hit the subscribe button. And if your podcast platform that you use allows for 5-star reviews, leave a 5-star review and actually leave the review about the show. It helps with the algorithm. And if you can, it's also helpful if you play the show a little bit as well on audio. And I think listening it to both audio and video gives you kind of both flavors of it as well. And it's helpful to reinforce a lot of the legal concepts here. We try to break it down, of course, in ways that everybody can understand, but we recognize that sometimes people who say we watch or listen to this more than once, that is actually a helpful exercise. So please listen to this on audio and not just video. And for those audio listeners, listen to it on the live stream video that is then on our YouTube channel thereafter as well. Also check out patreon.com/MidasTouch. patreon.com/MidasTouch. There are memberships you can join at Patreon with a lot of exclusive content you can only get at patreon.com/MidasTouch. One of the other features is we post some of our videos first on Patreon, so you can see and watch the videos first on Patreon. We also have exclusive podcasts on Patreon, and me and my brothers, we also host a meet and greet that we do on Zoom where you can ask us any question. We do that once a month. We're going to be doing that at the end of February as well. So subscribe now if you want to be there for the meet and greet for February and ask us a question and meet us and do all of that. That's on our Patreon account. Also check out store.midastouch.com for the best Midas Touch gear. We've got great Legal AF shirts, great Legal AF gear, the Convict or Convict 45 shirts. Check that out as well. Want to also announce a new partnership here at the Midas Touch Network with Harry Litman's show. It's called Talking Feds. I'm sure you see a lot of Harry Litman's content here on the Midas Touch Network. Subscribe to Harry Litman's YouTube channel as well. It's Talking Feds is how you find it. TALKINGS, Talking Feds, 2 words. Search for it on your YouTube channel, Talking Feds with Harry Littman. Subscribe there. Harry is now part of the Midas Touch Network, and subscribe to his YouTube channel. We're going to try to get that YouTube channel to get 100,000 subscribers by the end of March. Again, it's called Talking Feds. May as well subscribe to Political Beatdown, the new podcast I host with Michael Cohen on audio as well. Search Political Beatdown for some breaking news. Cohen's the main witness in the Manhattan District Attorney's investigation, so we get the scoops first here on the Midas Touch Network. And with all of these shows that you're seeing and that we're developing here at the Midas Touch Network, that's with your support. We're doing that through our Patreon. That's how we build this new programming out. And none of this is possible without you, the legal AFers, the Midas Mighty, the community out there. Michael Popak and I have such a great time spending this time with you, and make sure you subscribe to this channel. We're so grateful for everything that you do, and we're so appreciative. And every day I wake up just so motivated by the legal AFers, this community out there, and how you not just listen, but then actively utilize the information to support our democracy. So thank you all as well. Popak, did you want to give a final word to our legal AFers, or shall I sign off?
Prosecutions and trials, that's 2023 and 2024 on Legal AF.
Absolutely. Shout out to the Midas Mighty.